Okay, wow. For the sake of time, we always try and start at 12:30 just because the webinar is being recorded and nobody likes dead silence at the beginning. So I'm Candice. I am the Meeting and Events Coordinator from SECA. So today I'd like to welcome everybody who's attending, as well as our guest speakers today, David Horvath and Darren Kautz. Did I get it right, Darren? They're both from FH&P Lawyers, and today they're going to speak about what happens if you miss the lien period. I know every time we've had lien sessions at any of our conferences or networking events, there's always such an array of questions because every situation is probably so different, and I'm sure you guys know that better than anybody. So I just want to remind everybody that if you attend any of SECA's webinars, as well as our WIC event next week, you will get entered into a draw that's been donated by BC Concrete and Piling for an awesome Margaritaville blender, which the sun's starting to shine, so I'm sure we can all find good use for that. So I wanted to thank everybody again for attending, and today's webinar will be recorded and placed on the SECA website, so it's good reference after the fact. I also wanted to let everybody know that there's a chat as well as a Q&A at the bottom of your screen. And David and Darren have both agreed that they'd like to have questions as they go. So feel free to ask your questions throughout the webinar and they'll get to them as soon as they're done speaking. So Tim right now. Tim, you had put your hand up. Did you need to say anything? Unmuted them. Hold on 2 seconds here. Nope. Okay. Tim, if you have a question, please feel free to put your question in the Q&A and we can get to it at any time. So I will let David and Darren take it from here. Thanks, guys.
Thank you. As mentioned, my name is Darren Kautz, and I'm a partner with FH&P Lawyers, and we have offices in Kelowna and in Penticton. With me as well, our associate, David Horvath, who will help me with the presentation today. We are going to talk about options if you miss the lien period. And we think that it's important to talk about liens and your options right now, especially with COVID and what's happening in the world at the moment, because there have been some interesting issues that have arisen with regards to builder's lien currently. We also want to advise everyone that our slide and our discussion today is based on current law and current statutes that are in place, so it may change from time to time if changes to the law or statutes occur. And welcome everyone that has patched in live today and any that are viewing this via recording. So if you can all see the screen that I'm sharing, I will move on to our contact information. Again, please feel free to contact myself or David if you have any questions after the presentation. Our email and phone numbers are available in this screen. So we'll start off with the basics, the lien. As per some of the most recent cases and the statutes, a builder's lien is dealt with through the Builder's Lien Act. And a builder's lien must attach to a property in question. Now, the lien is a creature of statute, which means the court has no discretion to depart from the statutory requirements with respect to establishing a lien or a claim of lien. And what has been interesting recently, in fact, is the fact that the courts have been unable to extend the 45-day limitation period. So currently, many limitation periods for filing of civil claims and other such things in the courts have been extended. But because there's no mechanism in the Builder's Lien Act the courts are unable to. So that 45 days has continued even where in British Columbia other statute of limitations have been suspended. Builder's lien or claim of lien. Now, builder's lien. The lien right, which arises when work or material is provided, must be preserved by filing a claim of lien. If the court decides that a lien exists, it will make an order to that effect. A claim of builder's lien is defined as a claim filed under the Builder's Lien Act. Filing a claim of builder's lien does not prevent owners from dealing with their land, and the Land Title Office will carry forward the claim of builder's lien on the new indefeasible title. Now, essentially what that means is the builder's lien will attach itself to property, and it doesn't completely prohibit the landowner from going about with their property until such time as things like they have to refinance or remortgage. Often lenders will want to have a clean title, so they'll often deal with that then, or such other things as we'll further discuss.
So I'll move on from here. So as Darren mentioned, a builder's lien is a creature of statute. By that, we mean that it was created by legislature. So on this slide, we have section 2. This is the operative provision in the act that tells you what a lien is. So it tells us that a contractor or subcontractor or any worker can file for a lien in relation to an improvement, and it gives you some of the things or some of the definitions of that. So performs work, provides work, supplies material, or does any combination of those things referred to in paragraphs A or B. So the lien must have a price as well, and that's indicative in the legislation in this section. To the extent that the price remains unpaid, so any amounts that the property owner hasn't paid, which includes an interest of the owner in the improvements itself, the land in or under which improvement is located, the material delivered or placed on land. So this section is what a builder's lien act or a builder's lien is, and this is what the courts look at when you bring such a claim. So moving forward, next slide, please. When the Builder's Lien Act was created, it was created for contractors, subcontractors, workers, and there are 3 central concepts to the act. The lien. Without this act, workers, contractors, subcontractors, etc., would generally have really no means of securing payment other than possible claims and bonds. So by way of example, you have a claim, you file a notice of civil claim, it's onerous. You might not get paid at the end of that long litigation. A builder's lien allows you to put a claim on title and the owner must deal with it versus a long and arduous litigation. So that provides some flexibility. And the second point there is the owner's limitation of liability and the holdback. Now the holdback is enshrined in the legislation under section 4. Many of you may know what it is. Generally speaking, it is a 10% holdback of the price paid for the project. So by way of example, you have a contract for $200,000. The owner pays, is supposed to pay that, but holds back throughout the project 20 grand of that. And if for whatever reason the general contractor does not pay the subcontractors and a claim is advanced through this legislation, the owner is able to limit their liability with that 20 grand. So let's say the claim may be 50 grand. Now that 20 grand held as a holdback will limit that liability, so reduce that amount. So it's both for the protection of contractors, subcontractors, workers, and the owner as well. Now the last point there, and I won't go through much of the trust issues because this presentation is mainly about the liens. There's also creation of a trust there in section 10 that creates a trust fund for the benefit of a person engaged in connection with the improvement. A trust is money received by the contractor or subcontractor on account of the price of the contract or subcontract. So there's no real connection in land and the improvement. So the difference there is, and if we go to the next slide, I think it provides us with this point, is a lien is not in personam. By that, we mean you're not suing the person. You're not creating an action where you're saying so-and-so is responsible. It's an action or a claim against the land itself. A trust that I just mentioned would be something of the nature in personam. So that would be against the person. And you see at the bottom of the page there, the Builders Lien Act does create such actions. But the main focus of this presentation is really this lien, which is not in personam, but against the land. And if we go to the next slide, as Darren mentioned, there's this time limit for filing for a claim of lien. And that's set out in Section 20 of the Builders Lien Act. And I won't go through and read all of this, but suffice it to say, it is 45 days after the day on which the certificate of completion is issued or the work is done. Now, you'll have cases where there's a dispute when this 45 days started, and that's really a legal question when that period starts ticking. So it's really important to ascertain whether or not there's a certificate of completion or when the project was complete, abandoned, or terminated. And you see that at subsection 2 there at A. That's, I think if we move on to the next slide, that would be Darren.
Just picking up on what David said there with regards to, when is a certificate of completion occurring? That's, why it's often important to talk to a legal professional, because the definition itself in the Builders Lien Act is widely talked about. What does that mean? And there are a lot of things that council can do to help you understand and potentially deal with, did you not meet the 45 days? Was there actually a certificate? Have that provided by the other party to ensure that there was a certificate. There's lots of things that talking to your council will help you navigate and ensure that you're following the statute properly. Now, as mentioned, today we're talking about liens. You have 45 days. Responding to a 21-day notice to commence an action can be commenced after the lien is filed. If no 21-day notice, enforcement of a claim of lien is 1 year. So that's really important as well. If you file a lien on your own, you must initiate a civil claim within 1 year, okay? And then initiating the trust action 1 year after head contract has been completed. So you also must file at that point as well. Time limits, the triggers. And again, the Builders Lien Act, it's an old statute and many people want to see it revised, and there's really good papers out there that talk about things we could be doing to make it more clear. But these are just 4 things that can trigger the time limit. Again, it's important to talk to your counsel because they'll be able to walk through with you what these actually mean. COVID-19. So just before David gets into this, as mentioned, COVID has brought about a lot of issues for everyone, including the Builders Lien Act. And we just want to reemphasize to everyone that there are options. If you've worked and provided services and have not been paid and you've missed the 45-day limitation period, which with what's happening in the world right now is occurring, there are other options. And I'll leave it up to David to then review through.
Sure. So with COVID-19, the court system has experienced, in a nutshell, some problems in dealing with cases. So there have been specific ministerial orders, and we have these up on the slide, that try to affect Builders Lien Act. The first ministerial order on March 26 basically suspended any mandatory limitation period. And the question at that point in time was, how does this impact builders' liens? Does it? And on April 8th, the government clarified, and we have that up on the slide there, and the government clarified that it does not apply to Builders Lien Act. So throughout this period, this 45 days that we've been talking about is active, and the requirement to start an action is not suspended pursuant to the Act. So it's really important to keep in mind during even this period in time that these limitations are in effect, that you can reach out to legal counsel and see when that time period started or when it will start and what you need to do. And you know, the legal world has changed a little bit given this COVID-19 pandemic, and we're able to provide services via Zoom and virtually. So reaching out has become a lot easier to deal with these issues. So moving on.
Right, so if you've missed the 45 days, as David said, the 45-day period was not suspended, and if any of you have missed those 45 days, what can you do? Well, number one, you can do nothing. Number two, you can file a trust claim. Number three, you can file a claim and certificate of pending litigation. Or number four, you can file what's called a Shimco lien. Shimco lien. Now, Shimco liens are an interesting aspect that was brought about by a case with the same name, Shimco. And the definition of the Shimco lien is a lien against the holdback separate from the lien against land and improvements. And as you can see now on the slide here, the case is set out below. Essentially, as David talked about the 10% holdback, you're able to affix an interest in the holdback monies. And that's important because if you've missed the 45 days and you are not yet set to go through full litigation, you can actually file a Shimco lien through the courts as well to preserve your right on the holdback. Now, Section 4 sub 9 is where the courts of the Builders Lien Act discussed the application. Subject to Section 34, a holdback required to be retained under this section is subject to a lien under this Act. And each holdback is charged with payment of all persons engaged in connection with the improvement by or under the person from whom the holdback is retained. Section 8 sub 4, payment of a holdback required to be retained under Section 4 may be made after expiry of the holdback period, and all liens of the person to whom the holdback is paid, and any person engaged by or under the person to whom the holdback is paid, are then discharged unless in the meantime a claim of lien is filed by one of those persons or proceedings are commenced to enforce a lien against the holdback. So again, it permits you another avenue to secure at least some of the funds that you're saying are due and owing. And what I like about it is it permits you to, if you have to notify the other party that is holding the holdback, and it then freezes the holdback. And it permits you a way of, rather than having a builder's lien, which often forces the other party to pay attention and deal with you, it's another way for the party to deal with you without getting into full-blown litigation. David, I'll let you take over.
Sure. So we've mentioned this case, Simcoe, and I'll go through this slide in a moment, but just to give you background about this case, basically the case about the contract for construction of a tennis facility on land owned by the District of North Vancouver. Contractor was engaged by the district. They were unable to pay a number of subcontractors on the completion of the project. 7 subcontractors filed a claim of lien, but only 3 started an action. So we talked about how starting an action is important within that 1-year period. So 3 of the subcontractors did that in that case within the 1-year limitation period. And when you do that, you have to file what's called a CPL, a Certificate of Pending Litigation. Now, Simcoe Metal Erectors, filed a claim of lien and started a lien enforcement action, but didn't file that crucial CPL within the 1 year. Due to that failure, the Land Title Office removed the lien from the title. So Simcoe or their counsel came up with this argument that pursuant to the Builders Lien Act, we could then lien the holdback that I talked about, that $20K in my example. So Darren went through the acts and the provisions there and how the court kind of went through the analysis. So Section 8 sub 4 is what they looked at, and the highlighted note there, and it says, are commenced to enforce a lien against the holdback. That's what the court really engaged with when they made this case. And this case, to be very clear, is monumental. It was very controversial when it came out, and rocked the construction industry and said, well, how can this be? Created this dual system where the act, as we talked about, it creates this lien that you're able to do as a creature of statute. But now we also have this Simcoe lien, which really has no provisions for procedure. So we have 45 days for the regular lien. The Simcoe lien, though, the procedures in the Builders Act don't really indicate how you do this. So that makes this lien unique. So then we ask, so what? How does this help me? So as I mentioned, the 2 lien holders, a Simcoe lien holder and a regular lien holder under Section 2, are not the same. You can claim a Simcoe lien even if your 45 days has expired, which is great if you miss that deadline. But to be clear, you should not miss that deadline. It gives you more argument to get your money back, and it makes the case a lot clearer. But this mechanism, the Simcoe lien, gives you something extra to argue if that occurs for whatever reason. And it's only engaged by or under a particular contractor having a lien against the holdback retained from the contractor. So there must be this holdback that's in a separate account pursuant to the Act. And it only lies against this 10%. So that, in my example, that was that 20K that I talked about. Claimants who enforce liens on land may stand to obtain greater recovery than those who are only able to rely on the Simcoe lien. So that's the drawback, really, if you think about it. If you are within the 45 days, you're good to go. You may get more back, but if you're only going after that 20K in my example, you're not in a great position. So that's really the drawback there. So if the actual holdback is larger than the statutory 10%, and if the owner does not assert a set-off against the access to correct deficiencies or for another reason. So this really goes to your position as far as a Simcoe lien versus a lien that I just mentioned. So the moral of the story is make sure to be within that 45 days, but if you're not, this Simcoe lien really provides something extra for you to argue and get something back. And I think, Darren, I think yours is the next slide. Yes.
So just to reiterate what David said, Shimco, the reason we raise Shimco today is it permits you another avenue to look at. And one thing to point out, if the holdback has already been paid out, then there is no right to a Shimco lien. So again, we don't encourage you to wait too long just thinking that you have a Shimco lien that will last forever. If the holdback is paid out within the statutory rules, then you have no right to a Shimco lien. But if the lien holdbacks or the holdback still remains, then you can have a right. So again, we always encourage you to contact your counsel as soon as you have an issue, to make sure that you are not waiting too long and any of your rights have expired. And that's what has set out in the this slide here. Now, the last point, even if even one Shimco lien action is started before the end of the holdback period, there's nothing to stop other claimants from starting similar actions afterwards, potentially holding up the release of the holdback indefinitely. So it's good and bad. If one person starts a Shimco lien against the holdback, it does freeze it for everybody else, and then everybody else can kind of jump on board at some point. But then it also starts, I've seen it start a bit of a wave of everybody then attaching to the holdback. And if the holdback is not very large and all the claims are quite large, then potentially there's going to be a pro rata share would have to be divvied out, and you're still not going to get your full amount back, and you still might have to commence an action. But the good thing is you're going to get something. And there's many times where we come into these circumstances where there is no holdback left, and your only option is lengthy litigation where there might not be any recourse for actually getting monies back. So Shimco is good, and it does provide you with an ability potentially to get some of your monies back to help recoup some of your losses. Sections 23 and 24 of the Builders Lien Act. This is just a decision where the court outlined a process to substitute for the unavailable lien clearing mechanism under Section 24. And it just gives you, the ability of what a court can do in those regards. And if no other Shimco lien has been started, the holdback can then be released. So again, as long as the party complies with the mechanisms in the Builders Lien Act and releases the holdback, your right to a Shimco lien will expire as well. So again, you do not want to wait too long. You want to make sure you're dealing with it as expeditiously as possible. Even if you miss the 45 days, still try to deal with any other of your rights as quickly as you can.
Yep, and Darren, if we go back to the previous slide, by way of example and unfolding what Darren just talked about, this case that we cite here, Preview Builders International Inc. and Forge Industries Ltd. It's a great case. It's a foundational case where the general contractor, Preview, they were asked to renovate a municipal art building in Dawson's Creek. So they did that. They had some subcontractors, and the city was the landowner, so they were involved in the litigation. And Preview posted a lien bond of about $250K, and basically what this case came down to is the subcontractors weren't paid. In this particular case, Preview was seeking an order that upon putting monies into court, so the security that Darren mentioned, they were claiming to put additional $15K into court and sought an order for the holdback lien, which the subcontractors claimed. So subcontractors claimed this Shimco lien that we've been talking about, but Preview was trying to get it removed by putting monies into court. Court basically said in this case, you're right, you can do this, but you did it the wrong way. So the court ultimately dismissed the orders Preview was seeking, but said, like as Darren mentioned, yes, you're allowed to put money into court and for the Shimco lien to come off. But they also said that if any other subcontractors claim a Shimco lien, then the holdback cannot be paid out. So that's what really Preview was trying to get at, is trying to get that holdback money out. But once this case was adjudicated, another subcontractor sought a Shimco lien and the holdback wasn't released. So that's really the danger here, as Darren said. And this case is great for demonstrating that and making sure that it's understood that any other subcontractor can claim a Shimco lien and tie that money up.
Right. So, you know, the purpose of our discussion today was, in these uncertain times, we are here to help you with any questions that you may have or issues. Our offices are always open currently in COVID even, and virtually we can meet with anybody as well to discuss any concerns that you have. Thank you for listening. And do you have any questions?
It looks like Jeremy has raised his hand. So Jeremy, if you wanted to go ahead with your question. Jeremy? No. Okay. The hands have gone up. I know Tim raised his hand, but said he was fine too. So I don't know if it's just people clicking it or what. So I don't have any questions in the Q&A at this time, unless anybody, any of the attendees have any questions at this time. No. Well, I'll just take this time right now to thank all the attendees that came live to the webinar, and remind everybody that the recording, if there's questions, you can just review them on the website, because this is being recorded and will be posted to the SECA website, or share it with anybody that you think may be in the position where they've missed the lien period or whatnot. So I just want to also thank David and Darren, because it's nice to get a different take on liens. Sometimes there's so much information that, you know, you think you have a good idea of what you can do, but sometimes hearing what the other options are is also nice, as well as knowing the contacts, so that if anybody has any questions, by all means, you know, feel free to reach out to David or Darren or any of us at SECA if you need their contact information after this. So thank you again so much for your time. Thanks everybody for attending, and I hope everybody has a great rest of the week.
Thank you.
Thank you.